Greetings, how you doing? This is Tex Masson from thctrust.org. I hope you enjoyed that last audio file. I cannot tell you who the speaker of that was because that was something that was sent to me, and I actually clipped that segment out of a different speech because, quite frankly, I'm not, I don't think the person wanted me to share that, but listening to the speaker, he was clearly speaking to disseminate that information out there without restriction. He wasn't trying to restrict the information, so neither am I. Now, a trademark is actually part of our personal status correction steps at thctrust.org. So for those of you who don't know, we don't do secured party creditor per se. That's not to say that there's anything wrong with UCCs, but our process of personal status correction we feel is more precise and correct at resolving the issues that we are experiencing that we're trying to resolve. So you just heard the video about the common law copyright. I did a common law trademark, excuse me. I've done a lot of research on that, and I just wanted to show you that this is actually a part of our personal status correction, doing the trademark. So here's an example of the notice. For different reasons, ours goes to the privacy officer because the privacy officer is a government officer attached to a certain government agency who's responsible for maintaining and protecting information about your person that's maintained in that government system as relates to privacy. So the privacy officers are special because usually they have specific duties and obligations that they have to perform for you with respect to your private information or your confidential information or information that deals with your person. So let's just read through the notice here. So we notice we're serving the privacy officer. And actually, let me pull this up here because I had this on my screen last night. Maybe it'd be helpful. Yeah, here it is. So I'm just showing you, the Privacy Act of 1974. The Privacy Act of 1974 is a law that governs the collection, maintenance, use, and dissemination of personally identifiable information by federal agencies. Then, so that's the Privacy Act. Then, under the First Amendment, you have a right to petition the government for redress, right? So if anybody says, you can't send this notice requesting that the privacy officer make this update and send a system-wide notice about your trademark, well, that's protected under the First Amendment. You have a right to petition the government. Now, there's a thing called personality rights. Personality rights. Personality. Here's the word right here. Personality rights are associated with the person and protected by law. These rights include the right to privacy and the right to control the use of one's name and identity and the right to own one's reputation. So do you see that? This thing called personality rights includes the right to privacy, the right to control one's name and identity, and the right to control one's own reputation. So if you look at what a trademark is, it encapsulates one's right to use their name and their identity and one's right to use their own reputation, as in the brand that's associated with your name. Making money off of your name and identity. So this is what the trademark is all about. That's what's at the core of the trademark. The right to use one's name in commerce. And this is why this is one of the most important documents we could do as relates to personal status correction. Because at the core of what is going on is someone always in this commercial system is using our name to create securities or something of the like. For example, we know about the criminal system when they create the bid bond, the performance bond, and the payment bond. You don't sign any of those instruments. So although the signature does create the security, You don't sign those instruments. Maybe an attorney or some agent, representative capacity signs them, but you end up being liable. How is it that you end up being liable? Because your trademark or your trade name is being associated. Do you see what I'm saying? So we can see that without any protection of your right to use your trademark, which is your name, if you don't have any protection of that, it's used by governments all the time in commerce for making money. This is what the trademark protection is all about. That's not what the patent does. That's not what the copyright does. That's not what the trade name does. That's not what the fictitious name does. That's not what the DBA does. We are dealing with trademarks, so don't get it confused and think that something else will suffice. There's the it's called the Lanham Act of 1946. This is the federal act of Congress that governs trademarks, and it lets you know that the government issues trademark registrations, but that's not what we're doing. I believe now that I've been able to do the research, if you rely on the government to issue your trademark registration, it's complete because it's incomplete, excuse me. Because what you then have is a United States trademark. See, under the Lanham Act of 1946, it tells you that the government recognizes federal trademark registrations, which is issued by the U.S. Patent and Trademark Office. But then there's also unregistered trademarks that are recognized under the same law. Meaning, if you have a common law trademark or you own a trademark through usage, because that's the only way to have a common law trademark, to perfect it or to have evidence of it, is through usage. You can't get a registration issued from the United States, and they're not going to give you anything to acknowledge your common law trademark, and you can't publish it in the newspaper. That's not a sufficient way to secure or protect your trademark. The only way is through usage. So, as the person said in the last audio, by serving the notice of your trademark upon the General Counsel of the United States or the General Counsel for your county, you are actually using the mark. You're demonstrating, you're exercising your right of how this mark is used in commerce. And you're not asking them to register it. That's the quickest way to get it denied, right? We're not asking them to register it. We're giving them notice, which is a part of due process. It's a part of our First Amendment right. And I think it's under the Fifth Amendment. Somewhere in the Constitution, they talk about personal property cannot be taken without just compensation. This trademark is your personal property. The usage of your name in commerce is personal property. So I'm going to go through the trademark notice. Our trademark notice is consistent with the audio file that you've heard earlier. It meets all those requisites, and then it does more. We did some very in-depth research, even further research than what we've already heard so far. So let me just real quick, I'm going to go to the website thctrust.org to show you some of the other requisites that is very important that must be in the trademark. And then we're going to look at the template that I've prepared for the members of thctrust.org, and we're going to get out of here. But one thing I want to point out to you real quick, you can look up 37 CFR 102.23F, and they will tell you in there that the U.S. Patent and Trademark Office, they're not only are they a system of keeping patents and records and things for the federal government, but they're also an agency that has the ability to send out government-wide notices. So pay particular attention to that. That's why I was pointing out the Privacy Act earlier, because the Privacy Act creates obligations on the privacy officer to maintain certain information in a certain way that deals with your privacy. So you have the right to have that information altered, corrected, or adjusted to be truthful and correct. What I'm trying to show you here is that the Privacy Act officer, just like when you send the Freedom of Information Act request, depending on what the request is and the nature of it, it creates obligations upon these people. And when you actually go research, many of these type of inquiries that you send them may obligate them to respond and positively acknowledge what you've done. So these are just some things to keep in mind as we go through the notice, so you'll understand, how it's written. Now let me really quickly try to go to thctrust.org. I was already logged in here. So under personal, you can go under trademark or personal status correction. But if you go under the trademark menu, again, you have to be a member here, because you see that to see the template, you got to go to step 4 of personal status correction, because the trademarking is part of our personal status correction. So we're going to go down to step 4. We look at the trademark document, and we'll just read through it very briefly, and I'll point out some things. Oh, before we do that, what I was going to show you is, when I was doing my research, these are some of the things that we want to be in our notice, because we're giving them notice that our trademark rights are held in trust. Okay, so some of these things is, who is the owner of the trademark. That has to be known. The owner of the trademark, as you'll see, is the estate, the John Alex Doe estate, as represented on the land record or the birth certificate, because that's a land record. In some sense, it identifies land or the estate, and that is the source of the credit, right? The land or the real estate backs all of the credit, so that's part of the source of it. The specific type of good or service to which the mark is affixed, and it's how it is used in commerce. You can't be general here. So when I was researching this, the specific good or service is credit-based goods or services. The mark identifies the source or the origin of the credit that's used in commerce on any particular specific good or services. In our case, those are bills, bonds, notes, coupons. Commercial paper with the trademark affixed to it identifies the source of the credit in that transaction. So where the mark was first used is also something that typically they ask for on an application. Again, remember, we're not sending any application. We're just giving them notice of that we hold the trademark, so that they can respond, and that they can put this in the government record, so that there won't be any improper use of our name. We'll see. We'll get more clarity on that when we read through the notice. Where was the mark first used? It's a difference in where was the mark first used, and then where was the mark first used in commerce. As we stated before, the mark is the John Alex Doe name. It was first used on the certificate of live birth on land in the record. And then it was taken into commerce for usage and in trade and terrestrial waters, for use in domestic and foreign commerce, interstate commerce, for use on the high seas. So notice that you have the land and then you have the sea. So you see how when we're dealing with commerce, when this land record was brought into commerce, it's being used in a different type of way. We're letting them know that the trademark was held in trust. We're requesting, pursuant to our right to petition the government and pursuant to the government's obligations to maintain correct and accurate information regarding our personality rights, which is our right to privacy, our right to use our own name. We're sending our inquiry to the privacy officer, because we know already, based on the Privacy Act and based on the trademark law, that he's required to take action and possibly respond. Okay, so let's briefly look at the template, and then we're going to just go ahead and just call it a day, because I got some things to do today. So under 4, other affidavits, other recordings and affidavits, we're coming across the trademark. So we click the trademark, go through this as quick as we can. Here we go. So we'll start with the cover letter. This attached notice affects matters of commerce and trade and is intended for promulgation to all government record-keeping systems that hold my personal information and information protected under the Privacy Act of 1974. Agencies are to maintain the enclosed notice with said records as disclosure to affect the parties. Now, actually, I've been working on this, and it's even worded a little bit better. So let's go to the original here. This is actually my notice, right? So you see it goes to the privacy officer and these other parties. Those may or may not be the right parties, so do your own research. Dear Privacy Officer and General Counsel for the United States and Deputy Commissioner for Trademark Administration, this attached notice affects matters of commerce and trade and is intended for promulgation to all government agencies who have record-keeping systems that maintain information about my person, which is protected under the Privacy Act of 1974. Please disseminate and promulgate the enclosed notice with said records as disclosure to the affected parties, to all persons accessing said records. Notice to agent is notice to principal. Any questions or concerns regarding this notice should be directed to my agent at the email address or private mailbox provided above. Request is hereby made that you acknowledge in writing that said notice has been noted and recorded. We didn't ask them to register it or issue us a registration. We asked them to note and record our notice, which is protected under the First Amendment and the Privacy Act. We're giving them notice that the trademark is held in trust. Also, with this notice, this is again, we're dealing with privacy officers, so we absolutely want them to know to which state this notice applies. So I give my John Alex Doe name. This is the birth year. I provide the social security number, tax ID number. Since we're using a private mailing address, because we don't want to deal with any addresses in the public, I'm not going to provide any address, but I'll attach a notary certificate of acknowledgement. So that verifies this information. Now that privacy officer and every privacy officer of every branch of the executive government who hopefully shall receive this notice will make the appropriate amendments to the records they maintain on your person under the Privacy Act. Now, on my particular notice, because I'm a Moorish American, I used this flag here. Why? Because the trademark deals with trade and commerce. And we have a treaty called the Treaty of Peace and Friendship. And in that treaty, it's actually also called the Treaty of Amity and Commerce. So this is a treaty when it comes to Moors. If you're claiming the treaty, and you should, for many reasons, it's beyond the scope of this, but there's reasons why you should claim the treaty, and specifically Article 22, which is the favored nation clause, which basically is supposed to give you the same equal footing in commerce as the most favored nation. So this is more of a jurisdictional thing, because when it comes to a vessel, if you're in what they call, I believe, not territorial waters, but I forget what the word they use, but it's another thing like the high seas or territorial water. When you're out there, you're not on land anymore, so it's the flag on the vessel that's going to be prima facie in determining things such as whether it is a foreign state or domestic and things like that. So here's the notice. This is actual and constructive notice that the undersigned trustee holds the exclusive right to affix and display the trademark John Alex Doe. Now, let me say this real quick, because I know some people's wondering, well, if I'm going to trademark my name, should I do John A. Doe? Should I do uppercase, lowercase? What variation should I use? You can only use one variation. You can't provide multiple variations with your, that'll be improper. But the thing is, when it comes to the trademark, you're protecting the trademark which identifies the origin or the source of the particular goods or service in commerce. What we're identifying is the origin or the source of the credit that we're using in commerce. If somebody attempts to modify your name because you've trademarked it. So they want to say, well, we're going to create these securities based on this person, but we're going to use John A. Doe, or we're going to use a variation of it. When you get into what infringements and violations are of a trademark, unauthorized copying of the mark, using colorable imitations of the mark, altering the mark, and then using the mark in commerce, these are all violations and infringements and trademark violations. So you don't have to worry about doing variations of the name. Just with this particular trademark, you can protect all variations from improper use in commerce through the trademark law itself. Okay, so let's go ahead and continue. This is actual and constructive notice that the undersigned trustee holds the exclusive right to affix and display the trademark John Alex Doe TM in trade and commerce to identify the origin of credit-based goods and services as described herein. The usage or display of this mark on commercial paper, specifically bills, bonds, notes, drafts, coupons, checks, and related securities, indicates that credits being exchanged or transferred are owned by the estate of John Alex Doe, born September 11th, 1978, Ohio State number, etc., etc. I'm identifying the birth certificate as the person. I'm identifying the estate as the source of the credit. The above mark was first used in land records on May 14, 1978, and presently used in interstate and foreign commerce between foreign nations on the high seas and within the extraterritorial jurisdiction of the Moorish Moroccan Empire. That's because, again, I'm incorporating the special jurisdiction that exists in treaty, in the Moroccan American Amity and Commerce Treaty, also known as the Treaty of Peace and Friendship, because this treaty deals with commerce. It's a regulation on international commerce. And when I'm giving the United States notice that I hold the trademark in trust, that's related to commerce. So I'm letting them know that this is governed under the provisions of Article 22. The exclusive right to use said mark is vested in the undersigned trustee as evidenced in the attached assignment, enclosure 1. The trust holds the express authority and consent of said owner of said trademark, The trust holds the express authority and consent of said owner, and said trademark is subject to the provisions of Article 22 of the Moroccan Amity and Commerce Treaty. So let me speak on this real quick. Whether, I'm not saying that you can't you can't pay the $375 for the United States U.S. Patent and Trademark application, and you probably pay another $200 on top of that to have some attorney that knows all the nuances to get you through the door of trademarking your name, because generally you're probably going to get rejected if you don't know how to get through those nuances, because they're going to say that you can't trademark your name. And I don't know what reason they'll give you, but in my opinion, it's because this is at the core of what's going on. Blind trust in commerce is always being done in the background through fiduciaries on your behalf because you haven't secured that trade right. So they're not going to make it easy for you. And this is why I wouldn't request a registration from the United States to put my trademark under their jurisdiction, because now have I accomplished what I'm attempting to accomplish in preventing them from improperly using it? If it's their trademark, do they have some superior right to it? So no, I just want to give them notice that I hold the trademark. So I hope that makes sense. And under the Lanham Act of 1946, which is a trademark law that the United States follows, they recognize federal registrations that they issue, but they also recognize trademarks that are already in place through usage. So you can't publish and make your trademark official by publishing it or anything like that. But by doing things like this, giving the United States notice that you hold the trade right and letting them know the incorporated fee schedule, this is enforcement of the trademark. And remember, it's under the Privacy Act, so we're expecting them to perform. All right, let's see. Infringements and unauthorized use of the mark in commerce are subject to a fine of $10 million per occurrence to be recovered as compensation for damages. This includes any application in commerce not expressly authorized by this trust, including but not limited to reproduction, copy, colorable imitation of the mark in connection with the sale, offering of sale, distribution in connection with the loan or commercial obligation that is likely to cause confusion, mistake, or deception, as well as making any modifications to the mark and using the modified versions, marketing without express written consent, or using the mark in any manner that dilutes or tarnishes the brand. So remember, we was looking earlier. Well, hold on. Let's not go. Let's go ahead and finish this up. This notice creates a self-executing contract with regard to compensation for violations and infringements as outlined above, wherein, accordance to the law, private property cannot be taken for public use without compensation. See the Constitution Amendment 5. Additionally, states are prohibited from passing laws in accordance with the Constitution that shall abridge the privileges and immunities of citizens of the United States, nor deny to any person within its jurisdiction the equal protection of laws. So there you have it. Now, something else, I don't know if I mentioned it, but attached to this notice of a trademark, right, I have the assignment showing that the owner of the name, through his permission or through his conveyance, gave the authority the intellectual property rights to the trust. This is how you avoid anybody saying, oh, you can't trademark the name, oh, you're not, because there's plenty of laws that says if the owner gives you permission to use the name, you absolutely can use it. So this is a very strong, it's a small piece, but it actually something very strong that you want to include in your notice to the General Counsel for the United States and the privacy officer as evidence that the trust does hold the right to use that intellectual property. That was very quick, but I hope you enjoyed it. And again, create your membership at thctrust.org so you can have full access to this template and all the templates that deal with personal status correction. And also that gives you access, more access to me to get your questions answered. So thank you, and I hope you enjoyed this. Peace and love.